We're going to turn now to the police and the Constitution. In fact, we're only going to talk about a couple parts of the Constitution, really mainly the Bill of Rights. But we'll talk about the constitutional rules of law enforcement. This is a subject very near and dear to my heart. Again, it touches on the legal field, so you'll excuse me if I tell a few stories during this one. Again, here are the learning objectives. These are things that we want to cover. These are the broad themes we're going to look at, things like Miranda warnings in Terry versus Ohio, searches with and without warrants. These are often very general to look at, but like I said, they're the broad concepts we're reaching for to try to teach you in this chapter. Okay, to start off, it's fair to reiterate that there is a tension inside our system between crime control and due process. I was kind of reminded of this during this COVID-19 outbreak that we are dealing with this summer. And now that we're several weeks in, there is a growing protest between those who feel that it's more important that individuals be free to do what they want, for example, not wear masks, even if it might endanger others, versus those who say, no, it's more important that we preserve life. So it's a struggle between freedom and safety. So that same type of struggle can play out inside law enforcement. There is definitely and always has been a tension in our society between wanting to be free to do what I want and wanting to be safe. If you live in a completely safe society, there's probably very little freedom. I mean, solitary confinement cell is completely safe if no one's beating you up, but it's not a place I'd want to spend eternity. On the other hand, a completely free place with no rules is another dystopia, because it, begs the fact that it's going to be the rule by the strongest. So when we talk about crime control and due process here, due process are the rules the police follow so that we have liberty, so that we have freedom, and those terms are not interchangeable, even though we tend to treat them as such. There is a tension in the police between their desire to do their job, to have crime control, and the necessity to follow certain rules that will recognize the independence and the freedom of the public, but really, they feel at least, will stop them from doing an efficient job. So this tension, which I think is inevitable in every system, society has to periodically review it and look at it and say, okay, we're willing to surrender this little bit of freedom to get this safety, or I'm willing to give up this safety versus this because I want this freedom. And this plays out generationally over and over again. I was reminded during this whole mask controversy, again, that we're seeing during this, of the seatbelt issues that we faced. I'm a good deal older than most of you, and when I was growing up, there were no seatbelts in cars. There certainly were no airbags. And there was a huge fight in the 1960s as to whether there should be seatbelts, and whether we should make laws that say you have to have seatbelts on. Can you get a ticket without having one? And we still see some vestiges of that with wearing a motorcycle helmet. So there's always going to be these tensions around these rules. Alright, perhaps the most famous quote here is from Benjamin Franklin, and most people have heard a version of this quote. It says, "Those who would give up essential liberty to purchase a little temporary safety deserve neither liberty nor safety." Now, that's quote was actually taken out of context, but you should never let a little context destroy a really great quote. For example, in one of the Henrys of William Shakespeare, the remark is, "First thing we do, let's kill all the lawyers." And trust me, lawyers have heard that over and over and over again ad nauseum. Shakespeare meant something different than was what was written, but it's just such a tempting line that we hear it all the time. So today, we should think about the inherent dangers of either giving the police too much power that we wake up inside a totalitarian state, or that they have so little power that our safety is imperiled. So one of the things is, my first micro lecture on this is, what exactly is the Constitution? So we'll talk a little bit about the Constitution and what it means in modern America. And obviously, since that's an entire course that is offered here, it's not something in a micro lecture of 5 minutes I can cover, but I want to give you kind of a quick, very quick outline of it so that when I'm talking about it, some of the issues I raise, you might look at this micro lecture or listen to it and get a little more understanding. Okay, so as I said, when we're talking about the Constitution here, we're really not focusing on the beginning of the Constitution, the so-called articles. Article 1, Article 2, Article 3. Those really have almost nothing to do with law enforcement and our course. What we're talking about is the Bill of Rights. Those are the first 10 amendments to the Constitution, plus some of the others that impacted it. The famous Civil War amendments, the 14th, 15th, 16th, have some impact on it. But by and large, the first 10 amendments, and even not most of those. As an example, nobody, and I mean nobody, pays attention to the Third Amendment of the Constitution. The Third Amendment of the Constitution says you cannot quarter soldiers in persons' homes in times of peace. That means you can't stick the military in a person's house if it's not a war going on. Well, when's the last time that ever happened to you? So, certain parts of the Constitution nobody pays attention to. We're going to focus in particular on the Fourth Amendment and the Fifth Amendment in this lecture, because they are very important parts of the Constitution in regards to the police. Later on, when we go to the courts, we're going to look at cruel and unusual punishment. That's going to be the Eighth Amendment. We're going to look at some of your trial rights and a few others, but let's stick with the Fourth Amendment, which is search and seizure, and your Fifth Amendment, which the important part we're concerned with is your right against self-incrimination. So here's the Fourth Amendment. It's relatively short. The right of the people to be secure in their persons, their houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall be issued but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Now, a literal meaning of this would seem to say that you have the right when you're home or by yourself or what you've written or what you possess against any sort of seizure except a warrant. And any seizures or search has to be reasonable. Well, that's great, but it begs certain questions. First of all, there's two concepts that are critical in here. One is the prohibition against unreasonable searches and seizures, because if we go back to that, it says securing your house against unreasonable searches. So clearly reasonable searches are okay. So what's a search? When is it unreasonable? And when is a seizure unreasonable? Also, if you're going to get a warrant, we all know that warrants require probable cause. What is probable cause? And when does probable cause exist under the law? If you can't answer these questions, you really can't interpret the Fourth Amendment, because despite what some literalists might say, you cannot read the Constitution by itself. You have to read it in context. Okay, let's talk about reasonableness. The police must be reasonable when conducting a search or seizure. After all, we say no unreasonable searches. Well, ultimately, any reasonable search is dependent upon the factual situation of that search. There's one type of behavior if it is 12 noon, without the threat of violence, with reasonable people. You're looking for things that aren't weapons and aren't dangerous. That's one type of search. There's another type of search when it's at midnight, people are armed, people are drunk, people are violent, people have weapons. The type of reasonableness or behavior in each of those is different. And that means there's no specific meaning that can apply in all cases. Rather, you have to look to the probable cause and the unique facts of each circumstance. So, where do I get probable cause for an arrest or for a search? Because these two things go hand in hand. A search warrant or an arrest warrant, each are based upon probable cause. So remember, probable cause is not I'm absolutely certain, it's I'm pretty certain. Not proof beyond a reasonable doubt, that's conviction for a crime. Not proof beyond any doubt, but I'm reasonably certain. Okay, so there can be, so say the courts at least, 4 broad areas or ways in which probable cause can be established, where the police can find probable cause. One would be personal observation. Obviously, if a police officer walks into a room and sees Fred take out a gun and shoot Barney, he has personally observed a homicide. He has probable cause to make an arrest. That's observation. He might have training or expertise. He hears gunshots. He goes into a room. Fred is standing there. There's no other exits from the room. The gun is smoking. Barney is dead. Well, he should know that suicide's not uncommon, but, through a little quick investigation and observation and expertise, he should realize a homicide probably occurred. He has probable cause for arrest. The other way in which you can get probable cause for an arrest or search would be information, but it has to be believed and reliable. So let's suppose arrest, let's look at a search warrant here. If I come up to you and I say, "Oh, Officer O'Malley, I have evidence that my neighbor, Jane Doe, is cooking up meth." And Officer O'Malley says, "Well, how would you know that?" And I say, "Well, I'm a chemist. I recognize the smell. I've seen the drugs, the precursors to drugs she's buying. I know how she behaves. I've seen people there." Well, that's pretty good information. That would be enough to establish probable cause for Officer O'Malley to go out and get a warrant. But if I come up to Officer O'Malley and I say, "Hey, Officer O'Malley, my next door neighbor Jane Doe is cooking up meth in the basement." And he says, "Well, why do you know that?" And I say, "Because I was talking to my Atlantean spirit guide, Ashra the warrior, and well in commune with him, he told me that, yes, Jane Doe is cooking up meth." Well, obviously I'm loonier than a fruitcake, so it would be improper to rely upon someone who's clearly mentally disturbed as a basis for probable cause. So again, information has to be judged to be reliable, and police officers should be able to believe it. Now, the third area is among the strongest. This is because I am a great believer in the value of physical evidence. People can tell good stories, circumstantial evidence can arise, but if you can provide direct evidence of something, it is very strong in establishing probable cause. If you say, "This is the gun that killed Fred," and you can match the bullet to the barrel, and you've got strong evidence. But if you can't, you've got weaker evidence. So evidence can be developed in a number of ways, and we'll talk about plain view and inevitable discovery and a few things. But Physical evidence in particular is a very strong basis. The weakest type of evidence is association. And the police should not rely upon association by itself to establish probable cause. So let's suppose the police, think about someone who is arguably a saint, Mother Teresa. Mother Teresa spent a lot of her time with the poor, people that were drug addicts, people that were impoverished, people that had fallen into prostitution or very sinful and difficult lives. And she sought to rescue them. She literally was a saint. Well, the fact that Mother Teresa associated with bad people, even Jesus of Nazareth associated with tax collectors, and they're not anybody's favorite, or women who had committed adultery, if you read it. Even if Jesus is willing to associate with adulteresses or tax collectors, then the mere association with people can't be enough to establish that you're a bad guy. So merely associating with a criminal or being in a place where criminal activity occurs, that's not enough for probable cause. It might be enough to continue investigation, but it's not enough for arrest. And if that's your simple basis for arrest or search, it's going to get tossed. All right, so what do I mean by tossed? And this is where we start to look at the application of the Fourth Amendment. Now, this has a very long history. The exclusionary rule really has its beginnings in the early part of the 20th century. It's reaching its culmination by the middle part of the 20th century. And the exclusionary rule says this: if the police conduct an unreasonable or illegal search, and during this search they find evidence against an individual, that evidence cannot be admitted against him. Now, it has to be his constitutional rights that are violated. So let me give you an example. Without warrant, the police break into my home, and while in my home, they find out that I have a joint of marijuana. So, without a warrant, they came into my house, they conducted the search, they find the marijuana. The marijuana is inadmissible against me because my constitutional rights were violated. But let's suppose I said, oh, I bought the marijuana from Fred. Well, Fred can be arrested, and if you can somehow trace the marijuana to him, exclusionary rule doesn't apply to him because his constitutional rights weren't violated. Law enforcement is extremely critical of the exclusionary rule, and many judges are. Famously, Justice Cardozo, a very famous judge from the early part of the 20th century, said, because the constable has blundered, the criminal is to go free, couching it as this is a bad idea. On the other hand, to be honest, I think the exclusion rule is vitally necessary. If you say to the police, behave yourself, or what you find becomes inadmissible, they're going to behave one way. If, however, you say, don't worry, if you conduct an illegal search, if you don't bother to go get a warrant, or you don't have probable cause to arrest someone, and you find evidence they committed a crime, we'll still use it. Why are they ever going to go to bother to get a warrant again? Whose home is going to be safe? If the police can, whenever they like, simply enter a home and look for evidence of crime, anyone's home could be entered. And again, this tension between due process and crime control is going to be too far to one side. Now, the fruit of the poisonous tree is really an extension of this rule. It's rarely applied, but here would be an example to think about. Again, the police conduct a legal search of my house. They find a diary. Without warrant, they seize the diary, they read it, they say, the ransom money is buried behind the old well in the Smith farm. They know right where it's talking about, they drive to the Smith farm, they dig up the well, there's the ransom money. Okay. Because the initial search was illegal, and the evidence they discovered in the search violated my rights, the ransom money would be inadmissible against me. So not only is the diary inadmissible, exclusionary rule, but under fruit of the poisonous tree, so too would the ransom money be. Now, there's more to it than this. Again, this is a really fascinating case. It's called the Chinese laundry case in law school. It's got so many colorful names in it. It's like a 1940s Charlie Chan movie. You have characters called Blackie Tan, and you have illegal Chinese laundry, and it's really a fascinating case in some ways, and kind of hard to keep all the characters straight at first. But basically it says, evidence obtained through illegally obtained evidence is also admissible. Now, as I've said before, the Supreme Court of the United States has grown steadily more conservative as the end of the 20th century and beginning of the 21st century. So they have carved out a number of exceptions. Here are two that we'll mention. There are others. One of which is inevitable discovery. Let's go back to that ransom money. Let's suppose the police were already had a warrant, or they were lawfully searching the Smith farm already. And then they found the list, and it said the money's behind the well. And they inevitably would have, since they were doing a grid search, have found the money. That is admissible because it inevitably would have been discovered. The next one, and this was recently reflected in a case that came out of Raleigh, believe it or not. In Raleigh, a police officer saw a car that had one busted taillight. And believing that the law said if there's one bad taillight, that's a motor vehicle violation, you can pull them over. So he pulls them over. Turns out there's illegal evidence in the car. They seize it. They're convicted. They say, well, you didn't have the basis. This should be excluded. Goes up to the Supreme Court, and it turns out, at the time at least, that the Raleigh officer was wrong. The law actually said, no, both taillights have to be out, assuming they're not the turn lights, in order for it to be a violation of DMV. If one was still functional, it was not a motor vehicle violation. And the Supreme Court of the United States said, well, since he had good faith in believing what the law was, and was unaware of the error, the evidence is admissible. So there's less and less of the Supreme Court siding with liberty and more with the police under exclusionary rule. Okay, so privacy and search. When we start to look at searches, one of the key concepts here is privacy. Do you have an expectation of privacy? Is that reasonable? So the Supreme Court of the United States has a two-part test here to apply this. One, do you expect your actions to be private? And two, does society recognize this as such? So you might expect things to be private, but you're doing them in public, so the answer is no. I mean, think about how people act in cars. People act like they're invisible. They sing, they pick their nose, they put on makeup, they do all sorts of crazy stuff, with kind of the idea that they're invisible in some ways, and then clearly they're not. So there's one thing about how you behave when you expect that no one can intrude upon you in the privacy of your own home is a frequent expression. And there's another in which when society says, well, no, you're now in public, we expect you to behave and act in a certain way. One of the issues, and this is really going to be the subject of another micro lecture, is technology. Because in the past, the Supreme Court looked at things like physical trespass for search, particularly searches of things like mail and phones. So they would look for a physical intrusion. Did the police have to break in to place a wiretap? Did the police have to physically open the envelope? Well, and again, this will go to a micro lecture because I don't have time to address it in this. What happens when technology allows the police to be a lot less intrusive? Allows them to only lightly touch upon an individual. So an example here could be, and is, in the past, marijuana was frequently grown in people's homes, and the police would take infrared cameras, point them at the homes, and they could see heat signatures. Some homes that had grow rooms in them were giving off a tremendous amount of heat, and the police said, well, we didn't conduct a search, we just monitored the heat. Well, they couldn't do it with their naked eye, but they could do it with a machine. Is that a search? So we can see how electronics and technology impacts searches. Okay, I've been talking about the Fourth Amendment and warrants, and you should be aware that we're talking really about both arrest warrants when you're seizing an individual and search warrants when you're looking in a given area. Both arrest warrants and search warrants need to be supported by probable cause. So I kind of look at it as a ladder. Maybe this is a helpful way to think. For the police to get interested legitimately, to begin to question, they should be able to articulate a suspicion. Now, an articulated suspicion isn't enough to arrest someone, it's enough to investigate. Maybe even enough to pat them down, and we'll look at that in a moment. The next step up from there, if you can articulate a suspicion, is say, I've got enough probable cause to believe that you committed the crime. That's your standard for arrest, and that's your standard for search. Even more evidence up from there, and that's conviction, is I've got enough evidence to prove beyond a reasonable doubt you committed a crime. So there's really three tiers. Can you articulate? Do you have probable cause? And can you show beyond a reasonable doubt? So for search or arrest, we're looking at, first of all, is it a crime? People do bad things all the time. People lie. People are rude. But it's not a crime. So has a crime occurred, or will a crime be occurring? Or is there evidence of that crime? Or is the suspect in a location that you can search? So if you're going to get an arrest or search warrant, you've got to establish those two things. All right. Any warrant, an arrest warrant or a seizure warrant, must describe where you're searching or who you're looking for. So this is, and here's an important point I'd like to emphasize this. This is going to be a police officer going to a judge or magistrate and in writing saying, I believe if I search 15 Main Street, I will find crack cocaine. Or I believe if I search 5th and Main, I will find John Doe. Then they will sign it. And the reason it'll be signed and done under oath is that if this is not true, if they had no evidence to support that, and they are lying to the court, they have committed a crime. They've committed the crime of perjury. Even after getting this warrant, they must be reasonable. On tonight's news, I saw another tragic example of a police officer who had stopped a suspect for forgery, and he had him on the ground, and he had his knee on his neck, and he wouldn't release, and he killed him. That arrest is a violation because it is excessive of the seizure. The police may only use that level of force which is necessary. It is clearly not necessary to kill someone, to arrest an individual who is not violent, who has not committed a violent crime, nor that could destroy evidence in a way such that it kills them. So the police are limited on where they may search by search warrant or arrest and how they can carry it out. So what can you seize under a warrant? Well, you can seize items that result from a crime, such as money from bank robbery. You could seize items that is or are inherently illegal to possess. So if you found heroin, You could seize items that are evidence of a crime, such as a videotape of a crime, or evidence that was used in the commission of the crime, such as a gun. And you can see how sometimes the same piece of evidence could be present in any one of or multiple of these four categories. They're not exclusive categories to one another. It's also true that many searches are done without warrants. So searches may be lawful, and particularly you're going to see a search after an arrest. So let me give you a recent Supreme Court case a couple of years ago. It's an interesting case. We'll call our suspect John Doe. John Doe drives up in his car and he sees the police on the porch of his house. So he gets out of his car, he locks the door of his car, and he walks about 15 or 20 feet up to the porch of his house. And the police say, "Are you John Doe?" And he goes, "Yes, I am." And they say, "We have a warrant for your arrest." Now at this point, can they arrest him? They sure can. They've got the probable cause for the arrest. Where can they search? Well, if he's carrying a weapon, they may pat him down because they're going to bring him into custody. They can turn out his pockets. They can search anything that's on him. They can't go in the house because they arrested him outside of the house. They can't go to the car, unlock it, and search the car because it's not under his control anymore. One of the most common searches is a search incident to arrest, and that means the area within the arm's reach of the suspect can be searched without warrant, but that's it. You can't extend that into a home or into a car. Now, if he was still in the car when they arrested him, they could search the car. If they had come into the home, they could search the area immediately around him in the home. But since they got him on the porch, they were limited. The most common type of search are searches made with consent. So here's an example. One of the areas where a lot of drugs used to get smuggled into Raleigh, from which I got a few clients, was the Greyhound bus station. And sometimes the police would go up to someone in the Greyhound bus station and they would see a bag on the floor. And they would say, "Hey, that's your bag. Can we search it?" And the individual would say, "Yeah, you can search it." And the police would search it and they'd find drugs in it. And they'd arrest him for the drugs. And then I'd get a call. And I'd say, "Did you have drugs on you?" And they'd go, "Yeah." "Did the police ask to search?" "Oh, yeah." "Did you let them?" "Yeah, I said they could search." And I always wanted to ask, well, why? And I did several times. The answer was pretty consistently because I thought if I said no, they'd search anyway, and by saying yes, it'd be less suspicious. And it didn't work out for them because they were arrested. So these types of searches are very common. If a suspect, where you could just have an articulate suspicion, if you say, well, he's hanging around with the wrong people, remember that's the weakest type of suspicion. And you go up to them and you say, "Can I search?" And they say yes. That's it. You don't need probable cause. Now, it's got to be truly voluntary. You can't go up to a 5-year-old and say, "Can I search your daddy's house?" You can't go up to someone who's got an IQ of 65 and say, "Can I search?" You can't go up to someone who's bleeding or drunk or intoxicated. You certainly can't physically coerce them. And we will look at, with some suspicion, the length of questioning and the location of questioning to see if it's truly a consensual search. What about automobiles? Well, as I said before, despite how we think of them, we have a lower expectation of privacy in automobiles. So since it's lower, we allow more warrantless searches, in part because we're afraid that you could drive off. So you can conduct a search if you're arresting the individual for a crime, or if it's a non-intrusive search, and these are the famous drug dog searches. I'm not wild about these as a defense attorney, but it's really not been deemed to be a search. Also, why the police stopped you is irrelevant. but there should be some violation of law or some pattern. So this goes back to roadblock. And again, this is a little bit more extensive than I want to get into constitutionally. Here are two big exceptions, plain view and open fields. Plain view says the police do not need a warrant if they are in an area lawfully and if they see something which is clear evidence of crime or criminality. So here would be an example. A few summers back, I was painting my mother's deck, which was a redwood deck. And I was going from her house where I'd been painting to my house, which was several miles apart. And my shirt was covered with red specks. And a police officer had a roadblock and stopped my car. And he looked in my car, and as soon as he did, he put his hand on his weapon, because instantaneously I thought, and he did too, here's a guy that's spattered with blood. You know, if I'd gotten out of that car and that had not been redwood paint, if that had been blood, you know, that gives me plain view to certainly investigate further. Potentially, if I know someone's been stabbed locally or there's been a shooting locally, that's really good evidence I committed a crime. So you have to be able to recognize it as illegal or unlawful activity. And if you can't, you can't. But open fields. Open fields is you don't need a warrant if you're going onto someone's property, their land, that isn't enclosed, so it can't be inside a fence, or isn't in their house or the area immediately around their house. It's called the curtilage. So it comes as a surprise to people, but the police may enter open land or look into it without a warrant. Now, a landholder may tell them to leave, and they have to leave, and if it's enclosed, you can't go in. But it really gives the police the right to enter land, and people are very surprised by this, but open fields allows them to do it. Again, this brings up things like technology. One of the questions we're addressing is drone searches in these units. And, you know, think about if I can fly a camera. When does it become a search with a camera? How good can the camera get? So, you know, can I fly drones 24/7? If I put them up at the right angle, can I look in people's homes? I can look in people's second stories. Do you have an expectation of privacy there? So typically, searches have been approved by the courts without warrants or with less evidence as technology has advanced. And I think this problem really is an age problem. Most of the people that are sitting as judges are 20 and 30 years older than the current generation of technology. So they often don't understand technology or don't appreciate it. So whereas some judges would be very protective of snail mail, of a letter that's got a stamp on it, and saying, well, if you're going to open that letter, you need a warrant. Since they don't appreciate or maybe even don't utilize emails or Twitter, they're less protective of it. So new technology surveillance is typically allowed without almost any types of warrants. I tell my clients, or have told my clients in the past, don't put anything in an email or electronic communication that you don't want your mother, your pastor, or the police to see, because it's going to get out. And anything you think you deleted still exists. You're just fish swimming in an electronic sea. Okay, now we're going to move on to a really important area, and this is stop and frisk. I'll simplify this case. The case is Terry versus Ohio, so I'm just going to change the facts slightly. When you take constitutional law, you'll look at more details to it, but this is an easy way to think about it. So you've got Officer O'Malley, who's got 30 years at the force, and he sees three bad guys, Abel, Baker, and Charlie, ABC. And they're outside a liquor store at 10 at night, and the liquor store closes right at 10, and you know there's a lot of money inside the liquor store because Officer O'Malley, well, being Irish, like most of my ancestors, knows liquor stores have money in it. So he sees this and he says, "Oi, you know, Eladio, I think they're getting ready to do something bad." So the officer goes up, he stops the individuals. He doesn't at this point have probable cause. He makes what he called an investigatory stop. He could articulate a reasonable suspicion why he thought they might be about to engage in a crime, and he needed to investigate it. But he said, look, there was one of me, there was three of them, Abel, Baker, Charlie. Again, those aren't their real names. He said, so to protect myself, I wanted to frisk them for weapons. And when I did, I found that they were armed. Now, they were arrested for carrying a concealed weapon. They were brought into custody. Turned out, I believe, that some of them were ex-convicts, not allowed to possess weapons. They protested that there was no probable cause for the search. Goes up to the Supreme Court of the United States. The Supreme Court of the United States says, under the totality of circumstance tests, looking at the police experience, at their skill, if they can articulate a suspicion, they may stop an individual for investigation. They may ask him questions, and before they do this, for their own protection, they may non-intrusively pat them down for weapons. And I want to emphasize non-intrusive. If I pat your shirt pocket and I feel a sharp object like a knife, I can reach in and get it. If I touch your jacket pocket and I feel a bulky metal object like a gun, I can reach in and get it. But if I pat your pocket and I feel a soft piece of paper, I can't reach in, take it out, and read it. If I pat your jacket and I feel a round cylinder that's soft to the touch, maybe it's a cigarette, maybe it's a joint, I can't reach in and get it. The interesting thing statistically here is only 6% of stop and frisks result in an arrest, which means 94% of the time this suspicion the police have is unfounded. That in, close enough statistically, in 19 out of 20 cases, they don't have any case. So my question would be, okay, Supreme Court, you've given the police this power, but haven't you just really opened the floodgates to allow them to stop people? And of course, as soon as this was done, because like any tool that's developed, any organization uses the tool to its maximum extent. So the stop is this very brief detention. You have to have some reasonable suspicion that something's going on. Less than probable cause to arrest, sometimes called reasonable suspicion, sometimes articulable suspicion. The pat down has to be for protection, and it is for weapons, not for anything else. Not reading material, not dope. Having said that, if you inadvertently find dope, that's a different story. So how does that occur? Well, very often the police officer says, turn out your pockets for weapons, because I think you might have a gun in your pocket. Well, the police officer, if he's being honest, may not think there's a weapon in there at all, but he might think there's a joint. He knows he can't reach in and pull the joint out. He also knows if I make the suspect turn his pockets inside out and there's a joint in there, or crack or coke, that the coke is going to fall out. Now it's in plain view, now I can seize it. That's been permissible under stop and frisk. All right. New York City, not too long ago, conducted thousands of these stop and frisks. And here are some statistics. New York City is about a third white, 33%. But only 10% of the people stopped under stop and frisk were white, which means roughly 1 out of 3 whites were stopped. Blacks, on the other hand, were 25% of the population, but were stopped more than 53% of the time. Well, if whites only had a 1 in 3 chance, blacks had a 2 in 1 chance. So you multiply those, and it comes out to you are 6 times more likely to be stopped if you're black in New York City than if you're white. And one of the things I emphasize in this class, and one of the expressions I use, is if you look for crime, you'll find it. If the only people you stop for smuggling illegal parrots, I don't know, maybe there's a trade in illegal parrots. If the only people you stopped for smuggling illegal parrots were Guatemalan Germans who were over 6 feet tall, you would never catch anybody else smuggling parrots. So when the statistics came back and you said, well, who smuggles parrots? Well, look at all these Guatemalans we arrested for it. And they're all Germans. So it becomes a self-fulfilling prophecy. If the only people you stop are African Americans, or you stop them disproportionately, of course when you look at the statistics, they're disproportionately arrested for crimes. According to the law, a person's race, gender, or ethnicity by itself cannot be reasonable suspicion for a stop and frisk, but they can play some role. And again, this is that tension I talked about earlier in society. How much freedom are you going to give? How much crime control do you want? Should I be able to racially profile? I mean, let's stop back from racially profiling. Let me ask you this question. Should I be able to gender profile? You know or should know by now that men commit the vast bulk of violent crimes. So should I be able to, if there are two suspects, one's a man, one's a woman, profile and say, well, it's got to be the guy? Because 8 out of 10 homicides are committed by men. This is a homicide. 80% probability of these two suspects, it's the guy. Well, what about if I say, oh, well, you know, this is this crime and it's prevalent among Native Americans. Therefore, I'm going to pre-select Native Americans. So racial profiling skates awful close to the edge of practices we don't like. And sometimes you have to ask questions, are you searching for crime to find it just in this group? One of the hot button issues recently, for example, is in Arizona, law enforcement has been empowered to check immigration status of suspects if they look Mexican or Hispanic. All right. Should the same power be granted to searching for suspects who are arrested on the northern border? Canadians are, by and large, their typical Canadian picture is a white individual of Northern European descent. So any white individuals that you pull over in the state of Washington, Idaho, North Dakota, Michigan, parts of Pennsylvania, you got a river or lake between, New York, New Hampshire, Vermont, and Maine. Should I be able to search them? Should you treat white people the same because they look like white people living across that border, or is something else going on? Questions you have to address, not me. All right, the arrest, of course, is the seizure of the person, and it can arise a number of ways. The best way is a warrant. It also can be the perception of the officer. It also can be the discovery of evidence. To have an arrest, you have 4 basic requirements. You intended to arrest them, you have the authority to arrest them, you seized them, and they were aware of it. If those 4 aren't met, you don't have an arrest. You might have a crime, by the way, but you don't have an arrest. As I was saying a little earlier, arrest with warrant is best for the police because you've already gone before a judge or a neutral judicial magistrate and you've sworn out a warrant. You've named the suspect, the crime, the location. Why is that important? Because that provides you basically with immunity from a civil lawsuit if there's a basis. Typically, arrest warrants are served with a knock and a presentation of authority. A lot of TV you see, and no-knock warrants certainly exist. If the suspect is armed and dangerous, if the evidence might be destroyed, if there's an ongoing felony, these are all reasons not to knock. And no-knock warrants have become more prevalent. Having said that, still the majority of searches are knock warrants. So when can you arrest without a warrant? If, again, you commit the crime in the presence of the police officer, if the police officer has probable cause to believe the suspect committed the crime, and any delay might mean the individual escaped, if the suspect might fly, run away, or evidence would be destroyed, Location is often very important here. So, for example, public arrests are fine. You can do those without a warrant, particularly in North Carolina. But if you want to arrest John Doe, and John Doe's in his house in North Carolina, you better have an arrest warrant. You better not go in that home without a warrant, because courts in North Carolina friggin' hate that. There's a strong ideal of a man's home is his castle in North Carolina. And if you break that, it's likely that a judge will find a reason to toss that warrant. All right, we're going to shift from the Fourth to the Fifth Amendment here. We won't spend as much time on it. But one of the things about the Fifth Amendment, which is really your right against self-incrimination, it is your right to remain silent, is it is not triggered before an arrest. So the police need probable cause and a warrant to arrest you. But if they're just questioning you, if they're just investigating a crime, they can ask you a question, and they can use any basis for an arrest. One of the things you should be aware of course, is the exercise of the Fifth Amendment is not to be used as a basis by the police to arrest you. So if a police officer comes up and says, I'd like to ask you a question, and you say, officer, I don't want to talk to you, I'm going to exercise my Fifth Amendment right to remain silent. He can't say, well, that makes me suspicious. You must be the guy that did it. You're under arrest. That's not valid probable cause. Once you are under arrest, you have the absolute right to remain silent. That's your Fifth Amendment right. It's the right against self-incrimination. And it says basically, no person, and there's a little bit to skip in here, shall be compelled in any criminal case to be a witness against himself. But you can be required to give basic identification. What's your name? What's your address? Also, it's not self-incrimination if I take your fingerprints or your DNA or physical evidence if you're under lawful arrest. Now, if you're not under lawful arrest and I don't have a search warrant for those things, I've got to get them in another way. What about Miranda? Now, you cannot have lived in 21st century America without hearing Miranda read to people on TV or in movies. And you've all heard you have the right to remain silent. If you give up the right to remain silent, anything you say can and will be used against you in a court of law. You have a right to an attorney. If you cannot afford an attorney, one will be appointed to you. Do you have any questions? Basically, you can be quiet, you get an attorney, if you talk, we can use it. Those are your Miranda rights. And they really came about two cases, Miranda v. Arizona and the Escobedo case. You have to understand that Miranda is not triggered until two things happen. One, you're under arrest. And two, while you're under arrest, the police are questioning you. So you have to be stopped, and you have to be under arrest. If it's a stop and frisk, you're not under arrest, so Miranda's not triggered. If you volunteer information, you're not under arrest, Miranda's not triggered. If they're not interrogating you, if you're in a jail cell and you're talking to the guy next to you in the jail cell who's another criminal, not covered under Miranda. That's the jailhouse informant. And unfortunately for people, those are pretty common. Now, what about violations of the Fifth Amendment? If we talk about violations of the Fourth Amendment, what about violations of the Fifth Amendment? I'm sorry, my chair's squeaking a lot, but my dog's sitting on my lap and a little bit uncomfortable. Obviously, physical torture is a basis to toss any confession. The problem with physical torture, we've learned over and over again, is if you torture an individual long enough, they will tell you what they did, even if they didn't do it. Nobody holds out against torture forever, and the police have been known to do this. So famously, a police officer in Chicago who was actually promoted up and ran an entire unit for almost 20 years, between 1972 and 1991, he would take suspects to a kind of almost a secret precinct, I guess you could call it, torture them, get a confession out of them, and get them to admit to the crime, and convict them. I'd like to say that this was unusual, but it happens. Beyond physical coercion, the problem is even deeply psychological coercion can lead you to real problems. One of the most dramatic of these cases came out of New York City. This is the Central Park Five. 5 young men, I guess some of them were boys then, were black men, were arrested in Central Park and charged with raping a white jogger. She had no memory of the event. They were separated from each other. They were interrogated for long periods of time, and they were told other suspects confessed, and you should confess immediately, and things will be better for you, and ultimately many of them confessed. The problem was they didn't do it. And some of them served up to 13 years in prison for a crime they didn't commit, and maybe worse than that, the actual rapist was free to be out and raping other women because the police had coerced a confession from the wrong people, and that meant they didn't keep looking for the guy who really committed the crimes. So in 2001, thanks to DNA, the real rapist was identified. He was arrested. Ultimately, I think sentenced to prison. I'm not exactly sure what happened to him. But these 13 were exonerated. And I'd like to say this never occurs, but it does. So a couple points here to end on in the end of our hour is, and this is hard for me as someone who has a deep respect for the Constitution. I think the question can be asked, even if the answer is no, is the Constitution outdated? Do modern threats to safety or modern necessities for new rights compel us to re-examine the Constitution, compel us to find either new rights or a way of new restriction against it? Maybe the exclusionary rule is wrong, and maybe you need to give the police more power. On the other hand, maybe stop and frisk is wrong, and you need to grant the people more freedom from it. You can ask questions, does it make sense to exclude evidence because of police misconduct? As I said before, quoting Justice Cardoza, because the police have blundered, should a guilty man go free? On the flip side, how do you deal with wrongful convictions? And ask yourself, are they common? I know we often say to ourselves, these are rare, but how rare are they? And how accurate? One of the problems with any system is inevitably over any system myths grow up. And we started these classes talking about what people believe and how they act on what they believe, not know what is true. Do we simply believe that our system works, or do we have evidence of it? Also, what about the problem of the perception that one exists for the right, or the rich, actually, that should be, excuse me, and one exists for the poor? It's clear that poor people in our system are at a gross disadvantage compared to people that are wealthy. So you've had cases, I'm reminded of a case that was a millionaire who was, there was a movie about it with Steve Carell, some of you may have seen. He was an heir to the DuPont fortune, from which we get DuPont Corporation. And he was more than a little crazy, and he wound up killing people, killing a person. He was into wrestling. And because of his wealth and money, I don't think there was ever a real probability he was going to face the same level of scrutiny, jail time, prison, possible execution that a poor man who committed a similar crime would have committed. So I think the issue of the inequality inherent in the system is one that needs to be addressed. And that brings us right up at about our 1 hour. I like to try to keep these about an hour or so. And of course, that's the last one, I believe. This is chapter 6, so I think that's the last one before your midterm. Good luck in the midterm, and I'll be coming back to you with chapter 7. We're going to start dealing with part of my favorite part, the legal system. Other than that, have a good night.